Good afternoon, everyone. We're going to give it just 1 minute as people join us. We have quite a number of people joining us, so we're going to wait 1 more minute and then get started. Great. Good afternoon. My name is Brad Sears. I'm the Associate Dean of Public Interest Law at UCLA School of Law, and one of the people who helped found UCLA Law's new Center on Reproductive Health, Law, and Policy. Obviously, although this day was anticipated, it is a very difficult day to finally get the Supreme Court's decision overturning both Roe and Casey and declaring that the federal Constitution does not protect a right to abortion. A broad opinion in its scope, kind of devastating in its impact. But I think part of our message today is that a number of things have been anticipating this moment, getting ready so we can move forward from here. Today, we're going to hear from some incredible people who've been doing great work in this area. As I said, we're first going to look at the case itself, get a better understanding of what it means, and then see what folks, including here in California and Los Angeles County, are doing to prepare not only for this day, but to move things forward. I'm going to introduce each of the speakers in turn, and we're going to leave about 15 to 20 minutes for questions at the end of the presentations. With that, we're going to jump right into it with the McDonald Wright Chair of Law and Faculty Director of both the Williams Institute and UCLA Law's new Center on Reproductive Health, Law, and Policy, Carrie Franklin.
Hi, everybody. Thank you so much for being here. And I apologize for my voice. I've been doing a lot of talking today, so I am a little hoarse, but I am very grateful to be here with you. And I'm just going to talk a little bit about what this opinion said. I'll start with the doctrine, and then I'll talk about some takeaways. So abortion has long been held by the court to be a fundamental right protected under the liberty provision of the 14th Amendment. And because it is a fundamental right, the court has accorded restrictions on that right in some form of heightened scrutiny. In other words, when that right is burdened, when the right to abortion is burdened, because it is a fundamental right, we're going to look more closely at what the state is doing, and we're going to make them satisfy a higher constitutional test. And what that test has been for a generation is that the state may not unduly burden the right to abortion, meaning it can't place substantial obstacles in front of women seeking abortions. It can try to inform the choice of whether to give birth or have an abortion, but it can't simply try to hinder. So that has been the doctrinal framework for really half a century. This decision rejects that framework, and it overrules Roe and Casey, and it says that abortion is not a fundamental right under the Constitution at all, that Roe and Casey erred when they found that this was one of the liberties that was entitled to special protection. Abortion receives no special constitutional protection. And what that means doctrinally is that going forward under the federal Constitution, abortion regulations will be subject to rational basis review. If you remember back to Con Law 1, rational basis review is the easiest standard to satisfy. It is an easy test. Generally, regulations are upheld under this test. They are presumed to be constitutional. It is absolutely an invitation for the states to regulate abortion as they see fit. It's not to say that every single regulation going forward will be upheld, but there's a good shot that your regulation will be upheld going forward. And one reason I say that is the Mississippi law that the court upheld in this case. It banned all abortions after 15 weeks. It did not have an exception for rape. It did not have an exception for incest. It did not have an exception for preteens. It did not have an exception for the mental health of the mother or for any fetal abnormalities that could be consistent with life. And that law was upheld as having a rational basis. So This is a sweeping ruling that will profoundly change the landscape of abortion provision and abortion access in a lot of places in this country. Let me zoom out a little bit from that doctrinal discussion and talk about a couple of implications, some legal implications and some practical implications. Legal implications. This decision did not simply remove the constitutional protection for the abortion right. It adopted a new approach to discerning fundamental rights under the liberty provision of the Constitution in general. So historically, well, for over the last 50 years, the court has said the word liberty in the Constitution needs to be interpreted. What specific rights are protected under liberty? They're not listed in the Constitution. So we start with history and we look at the principles and the categories of rights that were protected. And we see that rights associated with families, with parents and children, with marriage, with bodily autonomy, with privacy, with sexual intimacy, these are categories of practices that Americans have long viewed as left to the individual and not appropriate for government intervention in many cases. And so the court has said, we start with that history, but history is the starting point. And we recognize that over time, we have new insights, we have new understandings, and that sometimes we define those rights too narrowly, and we cut out people, or we cut out rights that deserved to be in that categories, but because we had certain blinders on, we couldn't see it. And that's what the court said in Lawrence, the same-sex intimacy case, in Obergefell, the same-sex marriage case, in Griswold, the right to contraception case, that rooted, if you define the right at a very high level of specificity and ask whether it is deeply rooted in history and tradition, no, those rights aren't deeply rooted in history and tradition. Americans haven't always had the right to marry someone of the same sex, but the court said that's not the right test. And that over time, we see that these rights should have been in that bundle of protected rights. Well, today, the court rejected that longstanding approach to identifying the specific liberty rights under the Constitution and embraced this much more stringent, rigid test that looks back in time, not clear till exactly when in time or what the parameters of it are, but it said you ask the right, defined very specifically, abortion, marriage, what have you, has that particular right been protected throughout all history and tradition? And if the answer is no, you don't have a fundamental right and you're going to get rational basis. So I have been asked all day, what does this mean for the fate of Lawrence and Obergefell and all of the LGBT rights decisions? I will say this, we don't know. This doctrinal test makes those cases extremely vulnerable. They don't fare well under this test. In fact, the dissenters in those cases advocated for this test and said that those would not be considered fundamental rights under this test. However, it is possible that the court will find a way to differentiate those rights. It was at pains in this opinion to say its opinion didn't affect those rights in any way. I don't believe that that's true, but I also believe that we don't know, which brings me to my next point, which is we are now in an era of extreme subjectivity, where we have a test that is very hard to anticipate how it's going to come down. I think we have some real democratic accountability and rule of law problems because this test is extremely manipulatable, highly subjective, very susceptible to infusions of policy. As you saw yesterday in the Bruin case, where the court also looked at history and tradition and struck down a 109-year-old law that seemingly was deeply rooted in history and tradition, but the court cherry-picked the history in that case and found that it struck down that regulation of the Second Amendment. I will conclude by saying, I think one of the reasons that Gallup showed this week that the Supreme Court is at 25% approval, the lowest approval rating in recorded history of the Supreme Court. Many people who agree with its decisions are not approving of the way it's behaving is because the court is behaving like legislators in robes. They are implementing the policy choices of one political party. They are veering wildly from test to test, in subject matter area to subject matter area, and how they apply that test, in when they take this originalist view and when they don't. And I think that Americans are disappointed to see the court acting this way. I think that's one takeaway, that there will be a lot of organizing around the court and what the court has done and the anti-democratic nature of its decision-making and its processes. But I don't want to end with the court. What I want to end with is the people affected by this decision today. 75% of the people who get abortions in this country are at the poverty line or below. This opinion has rendered more vulnerable the most vulnerable Americans. We are talking about poor women. We are talking about Black women, Latino women of color, people of color, trans men. We're talking about rural people. We are talking about undocumented people. We're talking about people in states. The very states that will now ban abortion are the states that did not accept the Medicaid expansion, that do not provide food support, nutrition support, childcare, prenatal care. And I think we all need to, my inbox is flooded with questions about what can be done. So I'll just end with saying, one, vote, organize, vote, support candidates who believe in these basic reproductive and healthcare rights for all people, contribute to abortion funds that are trying to help these vulnerable people on the ground who are now going to suffer enormously as a result of this decision. Stay apprised of these developments, watch for the criminalization of pregnancy, look for ways to help, because we are entering a new era that I fear will cause a lot of pain to a lot of people before it eventually gets better.
Great. Thank you so much, Carrie. And I know Carrie's voice is a little hoarse today because she spent the day doing just what she did here, providing people with help and understanding the case and its implications. We're going to turn to another professor at UCLA School of Law, John Michaels, who is going to talk about some of the broader implications of the case. John.
Okay, thank you, Brad. So Carrie explained all the ways this court and this decision is truly devastating. And how the court, or at least is gesturing to, all the ways in which other core rights are being imperiled. There can, in my estimation, be no amount of fear and outrage that would be called unwarranted or hyperbolic today. My contribution to today's panel is to pull back even further and to underscore how this systematic campaign against bodily rights, autonomy, matters of private intimacy, precisely the focus of Carrie's comments, is actually operating in conjunction with what I see as inescapably parallel efforts that on their surface affect everyone equally, but which for sure have a disproportionately powerful and devastating effect on already vulnerable people and communities. This isn't to in any way take our attention away from Dobbs or suggest that the cases I'm about to discuss are more important. To the contrary, it's simply just to underscore how Dobbs is actually even worse when you think about it in light of all the other types of jurisprudential moves this particular court has been making. I don't have that much time, and there's great speakers after me, so I'm just going to highlight a couple of key points of intersection. So most recently, and again, something Carrie touched upon, we have the gun rights case from earlier this week called Bruin. One could make the obvious point that this court's abiding interest in life seemingly ends at the moment of birth. And that I think has a lot of rhetorical purchase, but there is again a deeper way in which the court is okay with state and private subordination, particularly of vulnerable communities, women, LGBTQ persons, and of course children. So this runs, disparate impact, the serious risk, not just in homes where there's domestic violence, and now there's also easier access to guns, but in school playgrounds, as we're all too aware of, and also in civic spaces where we've already seen around the 2020 election and racial justice protests in 2020, and even in public health meetings, county boards of supervisors in 2021, armed individuals, primarily men, who are very much a threat to democratic engagement of the sort that threatens today's white Christian male political and civic hegemony. So all the movements, all the efforts to rally, to protest are now under, it has to be seen in a more challenging way with the ease at which people have access and a willingness to use tools of political violence. Earlier this term, we had rules that struck down the Department of Labor's vaccine or testing requirements. This poses any number of challenges to everyone, but if we look at particularly how this has disparate impact on pregnant persons, and now especially pregnant persons who are unable to terminate because they have pre-existing health conditions, because they have comorbidities. This is just adding more ways in which the federal government or counties can't help the most vulnerable, who again are disproportionately poor and can't do necessarily distance employment or virtual employment, and have to be on the front lines and are the most exposed. Another case this week requiring states to fund religious schools commensurate with funding provided to non-religious school. This invariably creates more subsidized spaces where there can be wholesale discrimination against, say, unmarried pregnant persons, LGBTQ teachers, and also to sanctions very fraud instruction on issues of what are framed as morality, race, sexuality, gender, lifestyles, however it's framed. And now we all have to collectively subsidize it. And just to be clear, the schools that were issued in that case out of Maine both had histories of homophobic and transphobic policies. Next week, we're almost certain to get a case called West Virginia versus EPA, which will disempower the federal government when it comes to our ability to combat climate change. Again, this endangers everyone, but as we know, economic inequality very much dictates the ease or difficulty with which one can engage in self-help measures to at least partially offset some of the real and immediate consequences of climate change. And last, and as for my interest not least, there's the kind of blanketing issues of the court's sanctioning of vigilantism in the SB 8 case from this fall. That works in conjunction and tightens what's going to happen in Dobbs. It doesn't render the SB 8 moot. In fact, it bursts signals that there's no need to necessarily wait for Justice Thomas to get his wish and target all the other rights on his wish list to roll back the clock on, because you could use private enforcement outside of the scope of the state. And secondly, we're going to see in the coming days that blue county and blue city prosecutors are going to make big announcements that they're not going to prosecute abortion-related criminal offenses. SB 8 and its brethren, the Don't Say Gay, the Stay Woke Act, all these efforts that are going around the country, that allows essentially individuals to go into places like Houston or Travis County, where Austin is, and basically, no matter what the prosecutors are going to do, be able to attach civil liability to clinics that otherwise might be open, and effectively make it financially infeasible for them to stay in operation, even if they have kind of blanket guarantees that there won't be state regulation. So hard to end on a more disappointing note than one could in this space, but it's important when talking about coalition building, all the things Carrie ended, to be mindful about how all these pieces are actually working in conjunction, and how they're creating essentially what can't be, which I can't help but describe as a dystopian future for the ability of us to function as a free and democratic society.
Thank you, John. And John and Carrie, before I go on to Sapna, I think about 5 people have asked variations on a question dealing with Loving versus Virginia, and just would love to hear your thoughts about the implications on Loving, so on interracial marriage, as opposed to the more recent cases on LGBTQ rights.
I can jump in quickly on the Loving question. The decision does mention Loving, and Loving was in part based on the due process clause. And I would certainly say it fails this history and tradition test, as bans on interracial marriage are deeply rooted in American history and tradition. But I also want to point out that Loving was a completely hybrid decision. And in fact, more of that decision was based on the Equal Protection Clause, saying it was race discrimination to bar white people and non-white people from marrying each other. So today's decision does not wipe out Loving. I think Loving is firmly grounded in the Equal Protection Clause. And I'll just add that I actually think that can be said for some of these other decisions as well. And that will be something that lawyers will certainly be pushing, advocating, building on the idea that these weren't just liberty decisions. Only the liberty strand has been knocked down, but these decisions were all about equality as well. The LGBT rights decisions, they're about LGBT plus equality. And this decision today doesn't do anything to disturb that. So that will be an important lever going forward to preserve some of this. But I actually think Loving is on very firm equal to protection ground still.
The only thing I'll add to that very kind of comprehensive response is issues of reliance have kind of become questioned by this court. And there's something deeply problematic about suggesting that there are certain reliance interest in certain types of, let's say, domestic configurations and not others, such as same-sex marriage. So I am deeply troubled. As much as I might be relieved that Loving might be off the table, I'm also deeply troubled about the way in which different groups can be divided from one another and kind of classified in a certain hierarchy, which gets us back to, again, kind of much more kind of unequal, troubled times that we're all too familiar with.
Great. Thank you both. That was very helpful. We're going to turn to our next speaker now, also with UCLA Law's Center on Reproductive Health Law and Policy, and the appropriately named Sears Law Teaching Fellow, Sapna Karti.
So can I interrupt for 1 second?
Yes.
Apologies for that. I believe Senator Kahnlager has to leave at 3:30. I don't know if you're aware of that. I'll stop now.
I was not. So Sapna, if that's okay. We are very honored to have with us today California State Senator Sidney Kahnlager, who I think is going to helpfully point to some of the great things that the state has already been doing to prepare for this moment. Senator, we're having a little trouble with your sound.
Me now.
Great. Thank you. Yes.
The joys of working in a government office and not having great Wi-Fi. So thank you, Brad, for allowing me to go next. And also thank you, Sue. We have a caucus call that's about some other things that are also deeply impactful for Californians. I just have to say that I am a proud member of Planned Parenthood Los Angeles. And if ever there was a time to be associated with Planned Parenthood and to be a warrior fighting for reproductive health care and access to abortion care, it is now, it is now, it is now. I wonder if the reason why Loving is not on firm ground is because Clarence Thomas is in a interracial marriage himself. I don't want to get into talking about him, but I certainly believe that he should be recused, and that he and his wife have proven how egregious conflict of interest can be. And I actually think they both should go to jail, but that's just my own opinion. And I would like to add that this court has been incredibly activist and intrusive. And the additional decisions that come from this court are actually, I believe, going to further delegitimize the court, the law, and our democracy, which is incredibly fragile right now. But you certainly didn't come to hear me on my soapbox. So California has been working very hard, I think, in anticipation of this day. There was the FAB Council that was started on reproductive health care. It was a council of advocates and academics and stakeholders coming together to come up with policy decisions that could be submitted to the legislature this legislative session to help us weave together a structure and an infrastructure that would be supportive and protective for women seeking abortion, both across the state of California and those folks who come to us. This year, the Legislative Women's Caucus has prioritized uniquely this particular issue. There are 14 bills right now going through the Assembly and the Senate that focus on reproductive health care. Everything from cost sharing to abortion care to making sure that clinicians and providers and administrators cannot be prosecuted or penalized, to making sure that we have a trust fund or a revolving fund available for folks to help pay for abortion care services. There's a pilot program actually right here in Los Angeles that we are hoping will get passed through this legislature that would also allocate $20 million to secure infrastructure and healthcare services and reproductive healthcare services because Los Angeles County is deemed as a safe haven for abortion healthcare. On top of those 14 bills, we are rushing through the legislature in time for the June 30th deadline, a constitutional amendment that will enshrine the right for someone to get an abortion in California. So we are working hard, we are working feverishly to provide a playbook, not just for California and the cities and the counties within this state, but also for states across the land who are interested in being sanctuary states for reproductive freedom. We are trying to provide them, our state allies, a playbook on how we can all collectively work to protect women. Because we know in many states right now, women are living on islands where their state has now outlawed or is planning to outlaw abortion, and they are landlocked. They are surrounded by other states that have done or are planning to do the same. And we have an obligation to create an underground railroad for reproductive freedom that will allow women of all races, of all ethnicities, of all religions to be able to make decisions about their body to protect themselves and their families and their futures. I think it was stated that many women who are making decisions like this are doing it because out of financial reasons. Many women are living in poverty. Many women who get abortions already have children. And so it's really about making sure that if they're forced to carry through on a pregnancy, that they don't have their children taken from them, placed into foster care, that they are not criminalized out of poverty and reasons of poverty, that children are not homeless as a result of us forcing women to have pregnancies and to live in deep poverty. But we have a lot of other issues, I think, that will have to come before us, issues around extradition and how states work together, issues around, making sure that clinicians and providers and administrators that their safety is protected and people don't go after them because this law may infer or insinuate that you can do harm to those folks. So there are still many steps ahead of us that we have to find ways to make and take that will be legal and will be upheld by the Constitution and in court. But if you are seeking an abortion, you can come to California because we are ready to receive you. We have the funding, we have the infrastructure, and we have the compassion to receive you. So on behalf of the state of California, you can take those words to the bank.
Thank you so much, Senator. We so appreciate you being here. I have to say that one of the great things that you've helped do is create the center that we're all part of. The state allocated $5 million last year to create this new center. So we're here to work with you side by side and appreciate you taking the time to be with us today.
Thank you so much. Did you know that you were going to be needed like this now more than ever before?
We had a feeling, yeah. We had a feeling, yes. And we're so happy that you allowed us to be ready for this day.
Absolutely.
And to follow up on one of the things the senator said, one of our first reports estimated that we expect 10,000 additional people to come to California a year as a result of today's decision. And more than half of those will come to Los Angeles County. And so
which is one of the reasons, yes, which is one of the reasons why SB 1245 is so important, because we see that Los Angeles is a hub. It has many resources, access to amenities, points of access are easy and accessible because of, the airports and people, and so we know that folks are going to come to us because people have already been coming to us. But we also have to make sure that we shore up our infrastructure so that we can be ready, not just for Californians that come from other parts of the state, but for people who are coming from other states and even other countries.
Great. Thank you so much, Senator. I know
Thank you.
And our final two speakers are going to help us understand both sides of that dynamic. I was in the process of introducing Sapna, who most recently, who comes from the Midwest, from my home state of Missouri, and has been most recently working in the Midwest to give us a sense of the impact on folks there. And our final speaker will be CEO and President of Planned Parenthood Los Angeles, Sue Dunlap, to talk about how some of that infrastructure is being built out in LA County. But Sapna, let's start with you.
Thanks so much, Brad. I'm going to pick up on what we've talked about here and start by talking about the trigger bans that I'm sure you've been hearing a lot about and learning about. And I just want to break those down a little bit because there is a variety of trigger bans around the country. What these are is that basically they're bans or restrictions on abortion care that are now being triggered into effect since Roe versus Wade has now fallen away due to the Dobbs ruling. So what this means is that a number of states across the country, there's about 26 that have some type of trigger ban in place, but not all trigger bans are created equal. There are a couple that are immediately going into effect in 3 states, for example, South Dakota, Louisiana, and Kentucky. Those bans immediately went into effect the minute that the Dobbs opinion became public. So once that was released, those bans meant that folks in those states could no longer access care. Then we have states like Idaho, Tennessee, and Texas, where we have automatic bans that will go into place in 30 days. So there's a little bit of a window. If you have an appointment between now and then, keep an eye out on the news. But for now, keep your appointments, go get your care. But that's only for the next 30 days. Beyond that, you will have to find where else you can go for care. And yet there's still other trigger bans where there might be some type of procedural step that's needed at the state level. Usually that comes in the form of a certification. So as of just an hour and a half ago, there were an additional 5 states that had these trigger bans on the books and took that additional step of certifying those bans. And so now in Arkansas, Mississippi, Missouri, North Dakota, and Utah, bans are in place. So those bans have been triggered, which means that in all of these states, providing an abortion is now illegal with very few exceptions, if any, and they do vary by state. In Wyoming, we're going to see the ban go into place in 5 days from now. And then there's a handful of other states where there were pre-abortion bans or pre-Roe bans on abortion and other restrictions that may have been otherwise enjoined. And those will soon be litigated or just come into effect automatically once the state takes additional steps. That's going to leave people in 26 states without meaningful access to abortion care within a matter of days, a few weeks. So what does that mean? What does that mean for folks on the ground? What do these bans actually look like? And how do these impact folks? I want to talk about what this means in terms of what the bans are actually doing. A number of these bans and restrictions include penalties for people that are providing the cares or attempting to provide an abortion or providing even assistance to get abortion care. This is what Professor Michaels talked about when we're seeing a lot of these vigilante laws. We're seeing laws now that, we saw with SB 8 where we're having legislation that even criminalizes or is putting out some penalties for folks if you aid and abet anyone that's trying to get abortion care. But beyond that, for providers, the penalties range from a felony to fines that can go all the way up to $100,000 and up to 15 years in prison. Providers can also lose their medical licenses or have them suspended or revoked in one way, shape, or form. Beyond that, many of these restrictions across the country do not make any exceptions for rape or incest. Some of them may offer an exception for a medical emergency that threatens the life of a pregnancy, but those are rare. And we're seeing that a lot of those, there's already discussion on how we can limit even what those exceptions look like if they're even on the books. And I think Oklahoma is a great example of that, because while Dobbs was still being litigated, passed legislation that is extremely restrictive and completely guts any type of abortion care. While we've heard about a lot about medication abortion through the news, we've talked about it a lot in our various webinars, there are still restrictions that are being placed on those types of medication abortions. Currently, there are 6 states that have some type of an explicit ban on telehealth services for medication abortions. Those are Arizona, Arkansas, Louisiana, Missouri, Texas, and West Virginia. And there's 21 others that have some other form of restrictions on telehealth care. So this might mean that you still have to have 1 or 2 in-person doctor's visits before you can get a medication abortion. This is not even talking about the actual bans on the medication abortion itself. Medication abortion, just in case for folks that don't know, these are mail-ordered pills that can be provided to folks that can help induce an abortion. There's lots of services right now online that provide this type of care. There's a number of community organizations that have created networks to provide medication abortion. The FDA has said that both forms of medication abortion, both pills needed, can be shared with folks, and they're completely legal, and you can get them through the mail. But that does not mean that restrictions cannot be placed on medication abortion right now. One way to protect access for folks is for that access to be codified by the federal government. So for Congress to do something so that medication abortion remains legal. But until that happens, this is going to be a patchwork system that states get to decide. And so what that means is what, lots of folks have already said, and I'll just, walk away with this, that access for people has been difficult across the country. There have been folks that have been living in Missouri that have had to jump through a number of hoops, a number of hurdles to access abortion care. But those numbers of people that have been seeing barriers of access just increased 10, 20, 30-fold, because now it's not just a couple states, it's the majority of states in the United States that will be seeing abortion bans and restrictions. So this means that states like California, Illinois, Washington, Colorado, where we have abortion protections, where they are considered safe havens or sanctuary states, abortion clinics and providers are going to be seeing a much greater strain on their services, because they're going to be servicing an upwards increase of anywhere. I was talking to some folks in Illinois where they're expecting a 5,000 to 7,000% increase in the amount of care that they will need to provide, because they are located as the only safe haven in a sea of states that are restricting abortion access. So support your local organizations, support organizations in those states where we have these bans, the abortion networks, abortion funds, but then also put pressure on your state legislators to do more in safe haven states to protect folks that may be traveling in. And I think that's the perfect segue to Sue, who can talk more about California and what we're doing here in LA County to make sure we're prepared for everyone that's coming here.
Well, if that's the perfect segue, I'm just going to go. So even though I'm starting with a bit of a smile, I can't offer you a lot of optimism today. One of the things where we talk about when we sort of try to think about how to have a rational conversation about what's happening right now is often we talk about this happens in the law and that changes patients' behavior. I want to offer to you as a starting point in my remarks that that's not the way this works. So what's happening today all across the country is that people are waking up expecting to be able to get care, getting a phone call from a provider saying, I can't keep track of the law, our law hasn't changed, or maybe they don't say any of those things, but your appointment for today was canceled, your appointment for next week was canceled. There are other folks who don't have an appointment yet, but we're imagining they could call to get one, and who are paying attention to the news, but unlike us, aren't so focused on the nuance and the where. They just know that today, and frankly, they've thought this for the last 6 months, things got a lot harder. So what does that mean for us in Los Angeles, and why is it so important that, as other speakers have referenced, that we're a haven county? When people don't know where to go, One of the places they go and that they show up and that they call is Los Angeles. One of the other places they go to and show up and call is New York City. That's a 50-year plus history that just is. So what I can tell you is that if anyone is imagining that things are changing today, I want you to know that months and years ago, frankly, I would point to the election of President Trump. We started seeing a dramatic increase in the number of people who flew to Los Angeles, not because they had to, but because they felt they needed to, because they were afraid, because there's stigma, because one way or another, they did not feel safe, irrespective of what the law may or may not say, in their community, accessing abortion or sexual and reproductive health care, because sometimes people do fly here great distances for IUDs and other types of sexual and reproductive health care. So what does that mean for us in Los Angeles? So for us as providers, I'm a healthcare provider, it means that we've been planning for this moment for years. It means that the horror that we're facing today has been something that there's a whole group of people and organizations that have been planning for. I'm not saying we know what today looks like. I'm not saying we know what the next 3 months look like in terms of patient care. I'm not saying we know what the next 5 to 10 years look like. In this unprecedented moment, though, I do want you to know that Los Angeles has long known as a community that we have an outsized role because of the size of our population, because of the number of medical schools, because of the politics and dynamics where we can name that this is a haven. So as many of you are wondering and asking about what we do today, I want you to know that my job, that the job of Planned Parenthood Los Angeles, is to make sure that not only do we meet this moment, but that we're planning for 3 years, 5 years, 10 years out. So some of the work that we've already done is made sure that we have a clinical infrastructure that's attentive to airports, attentive to bus stations, to making sure that we have a depth of relationships with hospitals and other healthcare providers, to already be training well over 100 doctors a year in abortion care, to be partnering not only with local medical schools, but to be working with residents, fellows, and family practice docs from schools in the states that can no longer provide training on abortion care, to have deep relationships with law enforcement, to have deep relationships and anticipate deeper relationships with other types of infrastructure. So I'm going to say a couple more things and then I'll wrap up. So as we meet this moment, I want each and every one of you to know that Planned Parenthood Los Angeles, and each of us all across the country as providers, play different roles. But here in Los Angeles, I pointed to why we have a particular role in this moment. Our doors will stay open. We will do all that we can to provide first trimester abortion, second trimester abortion, train doctors, and provide the breadth of sexual and reproductive health care. But as we ask ourselves and as we meet in this moment where we're still talking about Roe versus Wade, I want you to know that as a healthcare provider in Los Angeles, my job is no longer to talk about Roe versus Wade. My job is to plan for logistics. And what I would ask those of you who are here in Los Angeles and here in California to consider is that this, and I recognize that many of you are here in the context of a law school, so I mean that a little bit differently, but for those of you who are not here contemplating the law, but are here today contemplating access to abortion, contemplating what does sexual and reproductive freedom look like. We don't know what the next version of this looks like, but I will tell you that today and for the foreseeable future, at my level, and what I would ask you to support is the logistics, the import of local government. I'm not looking to the federal government to take care of us anymore. I support the legislative framework that the state's putting in place, but where do we actualize infrastructure? That's in cities and counties, and that's not a conversation we're familiar with as advocates and as supporters, and we don't know how to actualize this moment we're in as a community, but as advocates and people asking what's next, I want you to know we're going to learn that together, but it is in many ways profoundly local, and it is not the conversation that we're used to having, which is the one about Roe versus Wade in the Supreme Court. even though that's vitally important, that conversation's not changing tomorrow. But tomorrow, our doors will remain open, and we will need the support of local and community partners, government, and leaders. Thank you.
Great. Thank you so much, Sue. I really appreciate all of you with us. We've had over 1,000 people on this Zoom, and we've had a number of questions. I'm going to try to group some of them together so we can get to a few in this final few minutes that we have. And the first, John, I wish you could, turning to you to help us out with, several people have mentioned in their questions, I guess what Sue said, she's not relying on anymore, which is the federal government. But obviously the president issued a statement today, as well as the attorney general. There's a piece of federal legislation that could be helpful. So some of what was talked today about was protecting the right to travel and protecting federal facilities that provide services. What is the role of the federal government in this moment?
Yeah, Brad. So you've touched upon, like, on the immediate steps is to make sure that the corridors of travel, of commerce remain open, that there aren't kind of effective roadblocks as people try to leave to find what the senator referred to as kind of sanctuaries and whatnot. There's a couple of points to just remember, and it's just the points of lamentation, if nothing else. But one, the Congress could pass a federal protection for reproductive rights today, tomorrow, yesterday. They may not be able to do it in January 2023, but there's really the only thing that's holding them back is the reluctance of some members of the Senate who at least are avowed to be pro-choice, who won't budge on the filibuster, which is an incredibly undemocratic instrument to ensure essentially that Democratic majorities can't pass laws in this climate. So, I mean, that's the first step. The first step is simply getting Joe Manchin and Kirsten Sinema to budge in ways that they haven't budged on voting rights, or they haven't budged on any number of other issues, which gets to the larger point that I'll just bring up, is that also teed up as an issue run into the 2020 presidential campaign was court reform. We didn't necessarily have to have this particular court in place when these cases were being funneled into the Supreme Court's discretionary docket. There are moments, and obviously hindsight doesn't really help us, but it is a moment of holding accountability and thinking about if by any chance the Democrats make gains in the Senate in this upcoming midterm election, that to not allow another legislative session pass where there isn't at least a good faith attempt to force the issue at the federal level.
Great, thank you for that. I just want to flag because also in our complicated system of government here, we do have native nations with their own sovereign powers and systems of law.
Brad, you hit your mute button.
Sorry about that, hit the wrong button. I was just saying I'm putting a link in the chat on our Native Nations Law and Policy Center, who did file an amicus brief in the Dobbs case and has been very active in thinking about the implications for Native nations as they move forward and react to this decision as well. But I'm going to turn next to Carrie because we have a lot of lawyers online. A lot of them have very creative theories for moving forward, and I know you have thought a lot about kind of now that Roe is over, we're free of Roe. What kind of theories are you thinking about to move things forward?
Yeah, I mean, I don't want to frame it as a silver lining because there is no silver lining to today's decision, but I'll at least say there's an opportunity. So 50 years ago, before a lot of current law was developed, privacy was available and Roe got decided on privacy grounds. And I think that one thing that has happened is that litigators and judges have stuck with privacy because it's Roe, it's because it's what we know, it's because it's what we have. We no longer have it. That means there are a lot of other theories and opportunities to develop argument, particularly in areas that were not as accessible when Roe was decided a very long time ago. One of those areas is equal protection. So sex-based equal protection law was not developed at the time that Roe was decided, and so it wasn't really available. It is now available. We've had Ruth Bader Ginsburg. We have 50 years of legal development under the Equal Protection Clause. We have had the court recognizing on numerous occasions that the regulation of pregnant women can violate constitutional sex discrimination law, can violate equality concerns. Equality concerns have made their way into abortion jurisprudence. Alito dismisses equal protection theories in the most terse and superficial way in this opinion. I don't think that's sufficient. I think we will see a lot more equality arguments about the ways in which some of these abortion regulations reinforce traditional gender roles, enact compulsory motherhood, and reflect outdated notions of women's role and hamper their ability to participate in society. I think there are First Amendment challenges that are already going forward where people who are members of religions that do not believe that some of these restrictions are consistent with their religious practice. For instance, there is a suit coming out of Florida where a rabbi has said, Judaism counsels if the mother is going to be in extreme distress, or the pregnant person will be in extreme distress psychologically, that she may, and in fact should, for her own well-being, have the right to get an abortion. Many of these abortion bans don't make exceptions for mental health. So there are free exercise claims that Jewish people or Muslim people can make to say, you're not allowing us to practice our religion. You're instantiating a Christian view of abortion that violates the Establishment Clause. It violates our exercise rights. I want to say I'm skeptical about this in this generation, whether equality or religious freedom arguments will prevail at the Supreme Court, because I've seen enough now to see the extremely inconsistent way in which the court applies these doctrines. And my guess is we are not going to make a lot of headway at the Supreme Court immediately. However, I just want to put in my final word as a plug. Work will go on at the state level in all 50 states. States have much broader protections. Many states, they have equality provisions, they have privacy provisions, they have liberty provisions. States have passed state equal rights amendments. There are state religious protections, all sorts of opportunities. And I think in a major way, the litigation battleground will shift to the states, and that some headway will be made, and that for the next generation, a lot of creative and important work will be done at the states. So those of you who are thinking about going into this area of law, think about the states, not just the national level.
Thanks, Carrie. We just have a few minutes left, and Sapna and then Sue, I want to end with the two of you. So many people are asking just specifically, what can they do? How can they help in this moment? And Sapna, why don't we start with you?
Thanks, Brad. Yeah, there's a lot we can do. I think one thing that you've probably heard a lot of, and that I will definitely reinforce, donate to abortion funds, provide them with the support, because they are grassroots organizations that are directly providing money and resources and logistical support to people that are trying to get access to care. So these are networks that are going to help pay for traveling expenses, cover childcare, and even help support any contributions needed for abortion services themselves. But then beyond that, donate and support other local community orgs that are doing this work. There's reproductive justice organizations across the country. Look at who's in your community, who's there helping these folks, because at the end of the day, abortion is just one piece of this larger puzzle. This is about a lot more than just abortion access. It's about making sure that folks have homes, that they have access to healthcare, they have access to food, they have other resources that they need. So any support you can lend to those community organizations that are located in places where they're supporting marginalized communities, working with them, living with them, that's incredibly, incredibly helpful. If you're a law student, if you're a college student, urge your college campuses and universities to provide additional repro health services and resources on campus, making sure that they have information for people, making sure they have access to, and where we don't even have to get to the point of pregnancy, and that we're preventing that care, and we're preventing the need for that care. by providing resources, but then get educated and spread the wealth of that knowledge that you're able to gain in your network. If I learn about medication abortion today and I tell my friend to tell her friends, we can ultimately get this word out to where more people will know what medication abortion is. The same thing applies for what a restriction in a specific state actually does. Not all abortion bans are the same. Just because you may live in Texas and you know about it does not mean that that's the same ban as what's happening in Idaho. So learn about your state and what's going on and spread that knowledge around, because that education is so, so critical to make sure that people understand that they may still be able to get an appointment in their state, even though one of their friends in a different state can't. And volunteer. If you're a lawyer, there's Repro Health hotlines. If When How has an amazing resource where they have a network of attorneys providing pro bono reproductive health law services and other legal services. So volunteer there. If you're a healthcare provider, see how you can help. If you can even go to a clinic and be a clinic escort or provide resources there. If you can provide mental health support, donating your time right now is really, really critical. And lastly, make your voice heard, whether it's on the streets, online, calling your legislators, emailing them, whatever we can do to urge any decision maker right now in the US to do their part. So even beyond legislators, urging companies to make sure that they're not supporting any type of anti-abortion steps, and then making sure that, you know, if they're collecting data that is invasive and tracks locations, or is you know, surveilling people and potentially making them vulnerable to criminal lawsuits, making sure that they don't collect that data anymore and urging them to stop. So making your voice heard in a variety of different ways is really critical here, and just another way to help.
Yeah, thank you, Sapna and Sue.
Yeah, briefly, I'll offer that this is not something that's going to be solved overnight. One logistical piece that I know is that many healthcare providers all across the country were not able to answer the calls from their patients today because so many people were calling to help. So I want to sort of share that this is the long game we're in now. It's not just today, it's the long game. If you can't get through today, if you don't have the answer you're looking for today, this is the fight of a generation. And I encourage you, this is my last point, Brad, I feel you nodding. I encourage you to imagine the future. Roe v. Wade was never enough. Abortion, we had the federal right, but we know that there was not equitable access across the country. We know that. So I would encourage you, as we move into this fight, to ask yourself, what are you fighting for? What is the world you can imagine, not defined by Roe versus Wade, not defined by the limitations of how we've thought about sexual and reproductive health care? What is it we want? Because this is now the fight of a generation to build what comes next, and we will succeed. But what are we succeeding at, and what are we fighting for? As a reproductive health care provider, I will tell you that what we had was not enough. My fight is not to go back. My fight is to go forward. Stop, pause, know what you're fighting for. Know that this is years of work, not hours of work. And let's get to that better world and that democracy we all want to live in.
Thank you, Sue. And I just want to add, and I'll put a link in the chat, our new center is also here for the long haul. We got started this year, but the idea is really to develop those theories that may not work in the next year or two, that will be ready when there's a court ready to receive them, and to develop leaders like Sapna and others who are going to lead the way to a different future. And I have to say, we've come so far since 1973 in terms of the science and the medicine and what we're able to do. And yet when we think about the status of our democracy today compared to then, is very much in peril. So I'll just reiterate something that Carrie said in her very first comments, that voting, being active, making sure that we maintain a Congress who is supportive of reproductive freedom, and state and local elected officials, and we get the right judges nominated. This is absolutely at stake, not only for reproductive rights, but for all the rights that we care of. I take great heart in having this wonderful group of panelists working on these issues. So I thank you today, and for the over 1,500 people who RSVP'd and over 1,000 who attended today, this webinar. I think all of you should know that you're not alone You're going to see that in protests and as people speak out today and over the weekend. Be sure to stay in tuned, sign up for our email list, and we will be here and continue fighting with you. So thank you all.